do sound tests and everything. Right. Good morning, everyone. Sound testing, if you can hear me, let me know. Just making sure that everything is clear. And today's Tuesday, 23rd of January. This is going to be quite an interesting discussion. Hi, Murray. Probably a bit controversial because there's a lot of different opinions out there and a lot of different talks on this subject. But I think it's good to listen to see different sides of the coin and understand what different people have learned. Sound is really low. No audio. No, why is that? Bear with me. This isn't good, is it? Let's have a look. Your volume.
Is it low for me too?
Is it low for you? Right.
Yeah.
What about now? Is that any better? Poxy bloody computer shit. Is that better? Can you hear me properly now? Yeah. So I've turned it up. I'm on my old phone because I need my new phone to. Is that right? So everybody can hear me now. I haven't crashed. Not very loud. Still not very loud. Or loads better. Better. Right. Okay. Thank you. Right. Let me see if I can maybe push that in better. Oh, I'm sweating. I'm here with a guest, Rob. He is going to be doing this via phone call. So again, we're just going to do a sound test. Hi, Rob. Can you just say hello to make sure everyone can hear you?
Hello.
I've turned it, I think, all the way up anyway. So yeah, that's it. Now think back. Yeah, okay, brilliant. And what we're going to discuss is Rob's journey on how he understands the law and how he's been fighting the system in the background. He's not public. He's not on Facebook. He's not, he still has a burner phone. And it is because of this gentleman that I've started the group Understanding Law, and we're going to go back to the basics, but I'm going to let him explain most of this. But the one thing we're going to discuss is where people might be going wrong or misunderstanding as from what Rob has learned. So if you could just share this live so that it it hits quite a few people, because a lot of people are sort of asking these questions, and we're going to get started. And then at the end, we're going to do a few questions, because whatever Rob can answer, he will. Whatever he can't, because he's not a law expert, he's not, but he spent 12 years, right? 12 years reading and studying law?
More than 15.
15, right.
Yeah.
And just for the record, Rob's first language is not English, and so therefore he had to learn English, and then he started studying. So if he can do it, we can all do it. Right, okay, share this live, please. Let's get a few people on here. I'm going to get started by asking questions. Rob and I were introduced by a friend, a lovely friend, who's part of the movement, and he's a bit of a little treasure. And I think I'm just going to pass it over to Rob and let him take us through it. How did your journey start, Rob?
My journey?
Yeah.
Started more than 15 years ago, really. Basically, just everyone else, things didn't actually sit right with what's happening. So what I had to do is involve myself into comprehending what I can do to avoid all of this confusion created. So what's the best thing to do? Well, what was the best thing to do for me was basically to start reading the law, see where do they get their ideas and where do they get their so-called authority.
Right.
So I've started drilling down on the definitions. It's really as simple as that.
And what did you learn through this? So you've told me, obviously there's a few books that I need to read, which are, as you call them, the heavyweights of law, which are people like A.V. Dicey and William Blackstone.
The law scholars, yes.
And from them, what did you learn from them?
Basically, the way they understood the law at the time, and the law was based on common law. I mean, statutory law was just literally in early beginnings. They were just sort of drafting it as per se.
So the foundations,
They describe the rights of the individual, basically, of the man or the woman.
Right. And so some people will say that William Blackstone doesn't have any relevance to the UK because he's American.
William Blackstone? No, he's an English jurist and judge. He lived in the 17th century here in England.
So why are people saying that the American law is not? Because there's a lot of people that are saying you can't use the American law, but they all swear to the same bar system.
He has used some of the ideas that were used in the American Constitution in order to do his commentaries on the laws of England. Yeah. But nonetheless, we need to remember the fact that everything that's happening within the United States derives from Old English law, all the way back from Magna Carta.
Right. So you have been fighting using the law and you've been having success. Now,
yes, and for the simple fact that I've been drilling down on the definitions.
Right, the definition. Do you think this is what people are missing? The definition of what?
Absolutely.
How to interpret
and
the law.
way they interpret it and the way they read the acts and statutes.
So do you believe that all the remedies are in law?
Absolutely.
And so what
they give you all the tools. All you have to do is just drill down on the definition.
Right, okay. So now...
And the way to do it and the way to proceed.
Right, so right now we have a lot of people trying to challenge the system. And I'll give you an example. I think the biggest one today is that we are trying to challenge the obligation for council tax. And, you know, there's some people doing some great work trying to prove in court that we do not have an obligation.
It's not the fact that you need to challenge the obligation. All you have to do is analyze the terms they're using. And every single definition they have that they can attach has a commercial term to it. So unless you're involved in duty, impost, excise, or customs, then that does not apply to you.
So you mean...
in commerce. So if you're not engaged in commerce, they don't apply to you.
So then how are they getting away with putting us in court saying that we have to pay council tax?
Well, again, the definition that they've managed to sort of brainwash people, if you like, into believing that they are the person, they are the resident, they live in a commercial accommodation, which is completely not true.
Okay, so when you say they are the person, maybe that's what we need to really look at, because we have had discussions, many of us, that say a person is in, you know, as in a dictionary, some people would say a person is like you and I, a man, a woman. Is that, that apply in law?
For that, it's quite simple. All we need to do is take the two pieces of legislation that they use to define the person. And that's the Interpretations Act of 1889 and the Interpretations Act of 1978. In the Interpretations Act of 1978, Schedule 1, we have the definition of the person, which is in quotation marks, right?
Right.
Now, that's very relevant because the quotation marks mean the fact that it's a creature of statute, yes? And then we have it defined as includes, yeah?
Yep.
And includes, this is very important because not many people have been able to define it. Includes, it's a canon which is used. It's a canon for statutory construction. Yeah? Because we need to understand the fact that the language is an imperfect way of communication. So in order to avoid any ambiguity or misinterpretation, these canons have been included and have been able to define correctly what it's being meant in the statute. And we're only referring to the definition within the statute. All right, so it includes, which is the canon expressio unius est exclusio alterus, yeah, which is the common law principle for construing legislation, right? It means that it includes everything within the description and excludes anything else.
A Latin term. So it's expressio unius
est exclusio alterus.
Alterus, right. So it's a Latin term literally meaning the expression of one thing is the exclusion of the other. And this is a common law.
All other meanings, or all other interpretations that could be attached to the same term.
Right, so this is what it says. This is a common law principle for construing legislation which holds that a syntactical presumption may be made that an express reference to one matter excludes the other matter. So could that be applied? So what you're saying is if it's not on the paper, it's not.
So if it's not within the description given to us by the Act, it excludes anything else. It does not apply any other interpretation of the same word.
So,
because, like I said, words are an imperfect means of communication, and there may be ambiguity. So words are more than often prone to it. That's why they give these rules, the rules of interpretations, rules of language, and the canons for statutory construction.
You're breaking
now,
up.
we also have a definition of it, because this is a negative implication canon, and it has to be understood, yes?
Right.
So expressio unius, also known as inclusio unius, is in Latin a name for the communicative devices known as a negative implication. In English, it is known as the negative implication canon. We counter the device and recognize it frequently on our daily lives. I'll give you an example, when a car dealer promises a low financing rate.
You're breaking up a bit, Rob.
Sorry.
Just, have you moved?
Is it better now?
Yep.
Right. So when a car dealer promises a low financing rate to the purchaser with good credit, it is entirely clear that the rate is not available to purchasers with a spotty credit. Yeah.
Yep.
So it only includes people with a good credit. That's just just an example. But for the purpose of the interpretation, it means just what it says within the Act and nothing else. So that excludes the human. That excludes the man, which is a human. It's not a man anyway, because you can't. Human. He's basically human's light. Yeah.
Right.
And man. So it's light of man.
Okay. It's
not the man, as stated in previous pieces of legislation. And we have a liberty of the subject, 1356, where it expressly says the man, that no man be put forward. So it didn't say that no person or anything. It's no man.
Okay. I'm still getting a very slight interference. I'm not sure if you've moved from where you were initially.
No, then I moved the phone closer to the window as well.
Right. So Because some people are saying that, you know, when you use the Oxford Dictionary, that the person means a natural person or a human. But you don't use the Oxford Dictionary in law, do you? What you know, how can we really be sure in law and use the right dictionary that it means a person incorporated or unincorporated, and that is it?
So the definition says that it includes the body of persons, corporate or unincorporated.
Which is a business.
Which, yes, an incorporated body. And also I've looked on the government's website because I wanted to see how they see the person as well.
Right.
So the legal person, they see it, they say, and I've got this link from the VAT register, the basic principle of registration, meaning of person.
Yeah, so I've got
the
here.
word person is defined in the Interpretations Act 1978 in Schedule 1 as it including a body of persons, corporate or unincorporated. In effect, there are two types of persons: legal person and natural person. A legal person is an entity or a body which has an existence separate and distinct from the personal, legal or natural, comprising that entity or body. The following they give examples of legal persons: corporate bodies, corporation sole, Scottish partnerships, European economic interest groupings. Now, just by that alone, where is the understanding that it defines a man or a woman?
So that's under legal person. There is no man or woman. It's all corporate business. That is
corporate,
it.
Because or incorporated means it's been registered in this country for the company houses.
Right. So a natural person, under their understanding in law.
Yes, it's a sole proprietor, which is a business owner, a self-employed. So, that's, I don't know, the carpenter. But the carpenter is not the person. The carpenter is the business that he's engaged in to extract money for whatever he requires, you know, daily living or going on holiday or whatever reason. Yeah.
So I've got
a
here
partnership.
I've got here, like on the government website, a natural person is a sole proprietor, a partnership, an unincorporated association. A sole proprietor is a natural person, and it is the sole proprietor who is the person. Sorry, a sole proprietor is the yeah, that's right. In the case of partnership and associations, it is the sum of the members that is the person. So what you're saying is that, if I understand this correctly, anyone in a job that is employed or even self-employed who are registered.
Yes, because of the way they look at it is the rights and duties. So they have a duty.
Right. So a policeman or a policewoman, the man or woman is the natural, but they are acting as a business, which is the person. So a natural person is still a business.
Yes.
So,
but how can you define? Because if I go back to the very origin of the word person, and the best way to do it is grabbing something which is called an etymology dictionary, and I have a concise dictionary of English etymology by Walter W. Skeet. So here it says that the person is, and it gives a couple of the Latin definition, the way it's pronounced in French, and it says that a person is a mask used by an actor, a personage, a character played by an actor, a person. Personare, to sound through. The large mouthed mask of an actor was named from the voice sounding through it. Per, meaning through, and sonare, to sound, from sonus, sound. That again
It's an act.
Does not describe a man or a woman.
That's right.
And that's the origin of the word. How the word was made.
So it's an act, it's a mask, it's a theatre show.
It's a mask. It's a creature of statute for the purpose of the statutory reading. But it does not define the man or the woman. And every single one of them has a business element attached to it, a commerce definition.
Well, so let's get this right, because some people are saying that the Interpretation Act, in fact, let's get it on here now, says, what is it called? Interpretation Act, is it 1978?
1978, Schedule 1.
Right. Let's have a look. I'll see if I can get person. The word person is defined in the Interpretation Act, Schedule 1, as including a body of persons, corporate or unincorporate. Now, some people will say that the word including means that it also includes a definition of the dictionary where it says a human. Like,
I would like to see where did they get that idea from. Because the sole purpose of having canons for statutory constructions and rules of language is purposely made to avoid the ambiguity, because it's a very ambiguous definition, yeah? We can all agree on that.
right.
So for the purpose of avoiding the ambiguity, we have the canons, which helps us interpret the term, the definition.
Well, if it says, like you say, if it's not on the paper, then it's not true. It doesn't say man or woman. And even if you try and bring something in from a dictionary that's not mentioned here, well, it's not on the paper, is it?
It's excluded.
So, and here it actually says a person, corporate or unincorporate. In effect, there are two types of persons, legal person and natural person. And we've already looked at the fact that both of them
do not describe a man or a woman.
A business. So therefore,
with constitutional, substantive, protected rights.
Where do we get those constitutional protected rights from?
We have the likes of a liberty of the subject. If you type up in your computer and you bring up the Interpretations Act of 1356, if you please, read out where it says that no man be put to answer. It specifically says man.
Interpretation Act of what?
No, liberty of the subject, 1356.
Bear with me. I've got 1354 maybe.
54.
Item that no man of what estate or condition that he be shall be put out of land or tenement, nor taken, nor imprisoned, nor disinherited, nor put to death without being brought in answer by due process of law. Well, this makes it really quite difficult, because then people need to understand the due process of law. And this is at the moment what a lot of people are fighting for, the due process of law. But what you're saying...
That's where AV Dicey comes into play.
Right.
With the law of the Constitution, or introduction to the law of the Constitution.
So, but what
the English legal system of jurisprudence has several main classifications for primary authorities of law. Constitutional being top, and we know it's top. And it was also proven in a case law that took place in 2002. It's Thorburn versus Sunderland City Council. Right? In Thorburn versus Sunderland City Council 2002, the hierarchy of statute was recognized. Constitutional statutes were considered as not subject to implied repeal because they protect the special status of constitutional rights. Hence, such acts are to some extent entrench and limit the parliamentary supremacy in the context of what it may legislate on. Examples of such statutes are Magna Carta, but if you look into the old writings, it's actually Charter, Magna Charta.
Right.
And then you have the Bill of Rights. But even before the Bill of Rights, we have the Coronation Oath Act of 1688, where it says that your spiritual, civil, and property rights are protected within that statute. Then to it, we add the Bill of Rights, right? Which again, everything is protected within it. Act of Settlement, 1700, again, describes how protected your rights are. But you need to know all this and timely be able to express them. So we established that constitutional law is top in hierarchy. Right. Then you have statutory law, which is second. Then you have administrative,
yep,
criminal, the rules, regulations, codes, and then case law.
Right. So this word person is actually very, very interesting because if used in the right way, then so am I right in understanding, because obviously from the conversations we've had, so what they've done is the word person is a creation of art, right?
It's a creature of statute.
So they've created the word person, which
created by the legislator.
Right. So that means that, right, because person is not a man or a woman, it is not, and as you say, in these superior acts that create the Constitution, it says spiritual in there. So
spiritual, civil, and property.
Right. So for the spiritual being the man and woman,
your beliefs, as in the right to believe in whatever God you may want.
Okay.
That's your spiritual belief.
And civil, what would civil?
Civil, see, a lot of people have made the confusion and made the sort of related it to Roman, which is not. Civil is your private rights. It's related to private.
So we are
that's
already,
your private rights.
So we are already in the private. That's what you're saying.
Yes.
So we don't.
There's no need for silly practices to, status change and all the other practices that people have been doing for a very long time. There's no need for it because you already have everything you need to protect yourself. And you already know this anyway. But for the purpose of being able to argue it within the courts, it's embedded, common law has been embedded into statute. It's been codified.
And they've done that from the word person. Someone's just asked, do you know who created the word person?
Yes, it was used just like my dictionary of English etymology says. It was used, but it was the description of a mask used by an actor.
This is actually quite interesting. So basically, it's the mask, which is the person.
Yes.
So that mask is the man or woman that creates the sound through that mask. So the mask is the fake, but the real is behind it.
Yeah, but it does not define the man or the woman, does it?
No. So
it just describes a sound made through a mask, as per the English dictionary of etymology.
So the mask is the fiction attached to the person. Now, so then they
attached to the man or a woman.
Attached to the man or woman.
But there's not defined the man or the woman.
Right. So how can? Right. So let's go back. When you say understanding the implications, the canon constructions of canons,
So for the purpose of statute and the way to interpret it, using the canons, this is why it's important to know the canons, to know the rules of language. So you avoid the ambiguity. You have to know the rules.
So if something
and the reason why I have success is because I follow the rules.
So if something is in speech marks, what does it mean?
In quotation marks means it's a term of art.
And something that is a term of art is a creation
of the legislator, which is Parliament.
Right, so now that makes sense. So the word person has been put in quotation marks because it's been created by Parliament, who is the legislator.
Yes.
As the fiction behind the man or woman.
Yes.
And so...
But still does not describe the man or the woman.
So what you're saying is we shouldn't be arguing obligation. We should be arguing person.
To whom it actually applies to.
So let me understand this. I'm just trying to break it down as simple as I can, so correct me if I'm wrong. If Parliament created person for the legislator, for the business of Parliament, therefore, under that business, person has become a creature of statutes.
Yes.
And the creature of statutes is who we are under Parliament. Because we are choosing.
Because the created cannot own the creator. We created Parliament. The people.
But they've put us under them by our ignorance.
Yeah, agreed. However, it still does not define that we are the man or the woman. They can employ any definitions they want. If they were to attribute it to us, they would say the man or the woman, every man and every woman. They would not use ambiguous terms prone to interpretation to describe us.
In fact, when I've received letters from the council tax that I've not paid for 2 years, and I'm still not paying, they've said the person, and they've used the word you, the person. They've not said, and as people say, obviously understanding language of capital letters and whatever. So it's the business. It's not the me.
They do believe that you live in a commercial property. They are under the presumption and assumption that where the place you're in care of, because you don't live there, you live in your body. Yes, so let's not make that mistake. The place that you're in care of, the address, is a business premises, which when it isn't. Unless you're involved in customs, impost, excise, and you're exercising business privilege, then you're not living in a commercial premises.
So how would you, because I know you have, and you haven't paid your council tax for quite a few years now, how would you advise people to educate themselves and challenge this?
It's quite simple. Drill down on the definitions. Pay attention to what they say within descriptions and how they define it. How they claim they have authority. Yeah. And you realize the fact that they have no authority over any man or woman. Right? They can only attribute all these definitions to commercial practices. The driver, again, is a commercial definition. A parent is a commercial definition. Which section is it within the Local Government Finance Act of 1992? What is the term they used to describe the property?
What, dwelling?
Which essentially is
a dwelling.
A dwelling, that's the one. That's another term that's bugging a lot of people.
Yeah.
dwelling is hereditament. Yeah. Now, of course, I did not know the definition of hereditament, so I started looking through case laws. Yeah.
Yeah.
And we have Woolway versus Mazars in 2015,
Right.
which describes the dwelling as a hereditament. Obviously, Lord Sumption
Yeah.
himself found the fact that the term is very ambiguous, is very unclear in statutory definition. So he goes over several pieces of legislation trying to define it, and he couldn't define it. And the rule is that when a term is ambiguous in statutory definition, the rule states the fact that you must lean towards any constitutional meaning of it. So it has to agree with the Constitution, which in turn has to agree with common law, yes?
Right.
So Lord Sumption said that a hereditament is real property. Now, anything that has real attached to it, automatically that's commercial. Because real property is real estate, yeah, which is another definition for a commercial practice.
Residential, commercial, industrial, and special use.
Yes.
So you need...
Again, how is that attached to you? Because you're not exercising any business privilege.
Yep.
You're not importing or exporting from your property. And then, of course, you do your freedom of information request, your FOIA requests and all that, and you ask them, to give you a clear definition of how do they describe your property. So then you notice the unlawful conversions. And then you address it.
Right.
Because even those that have a mortgage, yeah?
Yeah.
If you contact the land registry has you down as a proprietor, which is what?
A business owner. Business, yeah.
There you go.
So can you get that changed?
You could if you go to court. But for you to be able to go to court and express your rights and know the programming, you have to learn. And that's where the rules of civil procedure, the rules of criminal procedures come into play.
So then you have to know how the court system works.
Absolutely.
Now, so some people will say, they will argue the fact that people like you, and there's a few other people who haven't been to court, haven't won because you don't pay your council tax. They would say... The
bottom line is, if your paperwork is strong, if your facts are facts in law, not spurious claims, and you're able to evidence everything you say, they can't afford to go to court because they know they will lose.
So basically, just because
they'll just leave you alone and just go for the next low-hanging fruit. It's just as simple as that.
So what you're saying is that just because you haven't been to court, that shows your paperwork is very strong.
Yes.
Because they don't want people that know the law in court to set a precedence.
No. Because if you go to court over a council tax dispute, yeah, and you're not taking it to the magistrate courts where they like to circumnavigate the rule of law, yeah, and they employ all sorts of dirty practices. Yeah. You take it for the likes of the High Court, they cannot afford to have a case law because then you'll have everyone in the country suing. Because there's a precedent. So what they do, they just leave that individual alone and they just go for the next low-hanging fruit.
Do you think that if people with a mortgage, do you think people with a mortgage would have the same outcome? Because they've got a mortgage.
With the mortgage, I've not actually looked a lot into it.
No, I don't mean the mortgage. I mean council tax. So normally council tax, if you've got a mortgage, they attach it to your mortgage if you don't pay it. So do you believe that even if you have a mortgage, you can still challenge the council tax and they will leave you alone without attaching it to your mortgage?
Possibly. I've not been involved into that case, but possibly.
Because your
But
paperwork...
again, in order to be able to argue law, you need to be very first in knowing your rights. Obviously, that's knowing the constitutional law, that's knowing statutory law, that's knowing contract law, that's knowing equity and trust, you know?
And tort law.
And tort law, obviously.
That's quite a lot of law, isn't it?
It is, but, you know, it takes time to go over everything and read every single page of every book that's law related to grab the knowledge. And it takes time. Trouble is, people have been kept busy, if you like, with all sorts of claims and practices, like the straw man argument. You know, that was another practice which sort of steered people away from what they should be learning. And that's drilling down on the rules of civil procedure, learn how to move the court, learn the programming. Whether people like it or not,
yeah,
they are the name. The name is theirs.
Right. But it's how you navigate your name. It's down to you, right?
Yes,
So,
absolutely, but it is yours.
So someone just said, how can you get it into a high court? Now, you said under the civil procedure rules, you've got ways to move a court.
Pleadings, petitions, and orders, draft orders. That's how you move the court here in the UK. In Americas, they motion the court, but it's the same thing.
And they're very strong.
Absolutely. But you need to know the rules. So when they step out of line, you knowing the rules, you can keep them to it.
How hard would it be?
That's why I said you need to learn the programming.
Right. So how hard would it be to learn these rules? Surely, like I said...
It's up to the individual. If you want your rights, you claim them timely and you exercise them. And if you know them, you have them. If you don't know them, you don't have them.
So when we was talking about mortgages, obviously when you sign a mortgage, when you get a mortgage, you sign a contract. So then you've got to go into, that takes your, you've got to go into contract law to prove fraud, and that takes you into a completely different jurisdiction, doesn't it?
It's very important when people sign pretty much any contract. Your driver's license is a contract. Your voting registry or the registry card and all that. It's a contract. You know, the mortgage is a contract. Essentially, they say that the mortgage, from what I've been reading and hearing, it's actually a promissory note. The money doesn't actually exist until you actually put signature to paper.
Yep.
Right? So the way you pretty much sign anything, the way I do it, and again, people need to look into it, you can exercise your commercial code caveat, which allows you to keep your rights. Yeah?
Right.
And you sign it in UD 1-207, which means that you accept the ridiculous privilege, yeah?
Right.
But at no time you're giving up your rights. As what? As a living man or a woman at common law.
UD 1-207.
Yeah, UD means under duress. You don't want to sign it, but you have to sign it.
Right. And 1-207.
1-207. You exercise your commercial code caveat, which allows you to keep your rights. And you sign it UD 1-207 without prejudice. There's another way. If you don't want to, say, for instance, you get a ticket from a police officer and you don't want to sign it. If you don't sign it, it could go either way. It could let you go, or it could be funny about it. But you can sign it, again, by exercising your commercial code caveat. See, that's the beauty of knowing who you are. Because having statutory right does not waive away your constitutional protected natural rights. Yeah.
Right.
But if you sign it, just your signature, without, say, for instance, UD1-308, without
308.
prejudice, UD1-308 is quite simple to memorize. It basically means that I reserve my right not to be compelled to perform under any contract, agreement, or bankruptcy that I have not entered willingly and voluntarily. And furthermore, I do not accept the compelled benefit of such contract, agreement, or bankruptcy.
Right, you said UD1 308, not 207. So what's the difference?
207 is what I sign. I accept the ridiculous benefit. Don't really want it, but I'll accept it for the sake of being able to carry a piece of plastic in my pocket. So when the cops are asking me, I can present it, and I can avoid being unlawfully detained.
Right. And then the UD1 308.
But at no time am I giving up my rights to travel freely and unencumbered.
Someone's just saying here that they've been following the Peacekeepers challenge, and they've just received a second charge on their home. They're not having any luck.
Well, of course they're not having any luck, because unfortunately, and from what I've been studying, these so-called peacekeepers are riddled with spurious claims. And everything, I've listened yesterday to the definition of the person, I mean, no, there was no proof of claim in anything they said. Right? They just literally presented a slide done in PowerPoint and then just, on the screen. None of which showed me a proof of claim. Everything that I said to you, I'm able to evidence. That was a spurious claim. So unfortunately, I even have, with the peacekeepers, I have a friend of mine who has another friend. And he was in a similar situation, and he was faced with an interim charge. And when he approached back again the peacekeepers, basically one of them said that you might as well just pay it now.
Right.
So that to me is very dubious, to say the least. And that's not a good practice coming from someone who sort of claims that they're guiding people in the right way.
Right.
That's very ambiguous, to say the least. And I'm keeping a straight and polite face when I say that, for the sake of your listeners.
Thank you. But the point is, there are people that haven't had success because, again, there's been no wins in court for the obligation. I think there was a minor win for where the council tax retracted over a very small amount, but there's been no, big win.
We have, I think that case took place last year, end of last year. And it took place in a high court, but the guy actually had a case against the bailiffs who were trying to enforce the so-called liability charge.
Right.
And we all know that the judge ruled in the favor of the claimant.
Right.
Yeah. And in the end, Bristow and Suter were faced with having to pay £4,000 in damages plus interest. So that is a win, because the Bristow and Suter could not explain and prove that they had any authority whatsoever to enforce such liability.
Right.
And by rights, he was right.
Excellent.
Because the authority that the council have is limited and delegated.
Yeah, that's what you say. Yeah, I've just got it here after I made some notes from a long time ago when I spoke
and
to
if we look
Rob.
in Section 8 of the Local Government Finance Act, we find out that their authority is prescribed.
Right.
Which means is a right of claim by presumption or assumption. So they have no right, because it's assumed and presumed. But again, you drill down on the definitions, and you have to show them.
I hope this
because
is making
a lot of the
sense.
people that work within the councils,
yeah, they don't know, do they?
have been indoctrinated into believing certain practices, and what they do, they're not actually following procedure, and they're not following the law. They just follow practices, old practices. And that's why you nail them, because you always catch them on a technicality.
So, powers are limited and delegated.
Yes.
I'm just looking at some of the notes. I've got here Skillet and Garner reading law.
And their authority, it is very important to know. Yep. All this authority that they claim is limited and delegated. That's the police, that's your parliament, that's the House of Commons. Every single one of them have their authority is limited and delegated, and it derives from us. The political power of the government is inherited in the people. It derives from us. There'll be no government without the people.
But the government is abusing its power at the moment because the people have lost the knowledge of their rights.
Not necessarily have lost the knowledge, have been dazzled with, excuse my language, bullshit for a very long period of time, being kept occupied with other things which have taken their minds off it. Plus, in schools and even in law schools here in England, there's no education in regards to the individual's rights. What rights do you have? You ask the regular guy on the street, what rights do you have? And like, I have no idea.
Yeah. And that's because the constitutional law side of things isn't being taught, is it? It's more administrative now.
It's constitutional and administrative, yes, and it's more administrative than anything.
So what about the argument where equity will prevail? So, for instance, the argument is that even though the word person may not be, understood properly, common knowledge is person in the common knowledge is that, it's the men and women. But the argument by some people is that it doesn't matter, it's the substance behind it. So therefore, the substance behind it was the living man or woman, the person.
That's not what the Interpretation Act says. And I'm only relating it to what the Interpretation Act states.
So why do we only relate to the Interpretation Act? Is it because that is...
Because they've been telling us how they see the person to avoid the ambiguity. And that's why they gave us the canons for statutory construction. That's why we have rules of language.
So substance over form, equity, you believe that the Interpretation Act is stronger than that?
But to avoid ambiguity, they're telling us to whom they're referring it to.
Right.
So that's why I believe, and I know for a fact, right, it's not attributed to us. It was just literally, it was made to believe. It's an illusion that it's attributed to you. Because you have to. You don't have to do nothing. You don't have to do anything that does not agree with your moral compass. And plus, let's face it, we're only talking about now. Look at what they're doing with the so-called taxation. Are they or are they not using it to fund wars under the guise of help other countries?
Yeah.
I mean, it's all good and well helping other people, but you have not actually helped your people here.
Yeah.
You claim to help all these countries, but how many people sleep rough on the streets of England every year? How many military veterans sleep rough? They don't have no accommodation.
Yeah.
How many children are going to sleep with an empty belly? That's not the English way.
No. And
you look after your own first.
Yeah, absolutely.
And then anything else. And of course, you need to realize what you're doing. If what you're doing is actually doing a good thing or a bad thing. And during times like this, you might have a duty, again, which is a commercial element, yeah, to pay the tax with what they claim. But in times like this, you have a duty of not paying because you have a rogue government.
So how do you think we could restore the rule of law and
I don't believe in protests, and I don't believe in people going out on the streets and destroying properties and stuff like that. That's not how it works. And it's quite simple. Non-compliance. It boils down to that, non-compliance.
Some people will say that non-compliance is not fighting the system. It's actually more of a cowardly way. What do you mean by non-compliance?
Basically, everything they're asking you to do, and it doesn't agree with your moral compass, don't do it.
And
the reason why I say protests are not a form of getting anything back, it's because if anyone has the interest of studying the laws of celestial mechanics, yeah, they dictate that when two objects collide, there's always damage of a collateral nature. Yeah?
Right.
So when people are taking it to the streets, there'll always be damage of a collateral nature, and usually it's innocent people that suffers. So the more peaceful way of dealing with it is full non-compliance. You're not harming anyone. And that's the key thing. That's the main thing. Not to harm anyone and anything and whatever you please to achieve.
Someone's just asked, what happens when they take the money out of your wages or benefits?
What happens when they take the money out?
Yeah, of your
I don't know.
Wages. You haven't got to that, have you? Because you've
Well, no, because I follow the rules of civil procedure, and I always issue, and I'm always ready. So before I even do anything, I'm always ready. Even if I have to go to court, I know the programming.
Yeah.
I know what I have to do. And I'm always representing myself. I don't have to hand over my power of attorney to anyone to represent me. But I'm always ready. So when I'm issuing something which is called a letter before action, which is what they teach you in the CPR books, yeah, before you even take it to court, you would send them a letter before action. You outlay all their wrongdoings, their damages they're doing to you, yeah, to build your cause of action. Duty, breach, and damages. They have a duty towards you, yeah. They're breaching it through their spurious practices, yeah, and they're causing you damages. That's your cause of action. You outlay on a paper. You show them what they're doing. And then if they carry on, you take them to court and you sue them. And they can't claim they didn't know, because they did. You outlaid it really nicely on a paper for them.
Right.
And I always address the man or the woman in charge.
Yep.
The CEO, because we all know that councils have CEOs because they are a business, they are a company. So you address the CEO. And you use something which is called the common law doctrine of agency, respondeat superior. He is responsible for the actions of his subordinates.
Right, say that again. So you use the common law
doctrine,
yeah,
of agency, respondeat superior.
Because he's the one responsible. Right, okay. So common law has a big play in all of this, doesn't it?
Yes, of course it does. It's been codified into statutes. So you have to find out where they are, and get it out and use it.
I hope this makes sense to everyone. So, I'll if anyone's got any questions, drop them in. But I'm just going to recap to make sure that we've got this right. Everything to the term of the word person and knowing who you are is in the Superior Acts and Statutes. It's in the Interpretation Act, 1978, and you said there's, I think, a previous one as well, 1889 or something. And it is literally there. So, you know, when they say, for instance, could this be also used? So, you know, when a coffee shop says no dogs allowed, yeah.
Yeah, it means literally just dogs.
Right. So it doesn't mean, you know.
Now, if they were to define it, no pets allowed.
Yeah. That's all
then
animals.
You know that they are referring to cats, mice.
Yeah.
I don't know.
But the point is, if they
Snakes.
just mention no dogs, because they haven't put on the paper any other animal.
Have to put no dogs, no cats, no bats, no mice, no rats, no nothing.
Right. Yeah. So, and that's where the Interpretation Act, you have to learn to understand the canon constructions, that's of law.
The canons for statutory constructions. It's a rule. And then you use another common law principle called aegis dem generis.
What's that?
Which means of the same kind or class.
Aegis.
So once you've proven the fact that the person is referred to a business using this common law principle of aegis dem generis, they can only refer to it as a business.
Right. So what is it? Let me just write this down. Aegis
dem generis, which means of the same kind or class.
I'm just trying to find it.
There's another common law principle of nocitur astosis, which is words known by the company they keep.
It's quite interesting, isn't it? And it's all in the books. If you
yes.
Of the same kind, the general word shall not extend in its effect beyond subjects aegis dem generis.
Yes.
As the same kind or of the same kind. But again, these are all things that everyone can learn if they wish to. There was something else I was going to ask. Right, so let's just make sure. So in the Interpretation Act, we've got what it says, that it is not a man or woman, it is a business, being natural. And as you said, it's also how the government sees us, and we can verify that if you go to the VAT link.
Gov.uk.
Yeah, gov.uk. This is how they see us, and they define it in their own...
Well, it's not how they see us, it's how they see the person.
Yeah.
Because that's not the way they see us.
True, the person. So that's there. I think you sent me another link. So legal person and natural person are both a business, not a man or woman.
No.
And if you look at the Financial Conduct Authority, a person, in brackets, in accordance with the Interpretation Act 1978, any person, including a body of persons, corporate or unincorporate, and that is a natural person, a legal person, and, for example, a partnership. So that's under the Financial Conduct Authority. Nowhere,
does that describe a man or a woman?
No, nowhere there is it a man or a woman. And if we look at the
with
dictionary,
constitutional protected substantive right.
No, and if we look at, I've got to take this pillow away. And if we look at the dictionary, which I don't have one here at the moment, but people will look at the name person, it will say a human being or a human. which again...
Yeah, and what does it say? Though by statute, yeah, is a corporation, association, partnership, yeah?
Right.
Does that sound to you like a man or a woman? They even tell you, though by statute.
And do you know, and if you look at human, because it also in some dictionaries says sea human, if you look at human...
it says sea monster.
Sea monster.
Yeah, and monster is defined as one that cannot own or possess property.
So
who is that one? Again, ambiguous definition.
A notice of liability order is not a liability order. No, that's right, it's not. So I think it's clear.
Well, that liability order practice went out in 2003.
Right.
You know, that practice stopped in 2003. You can't attribute it. So by that alone, you realize that, you know, they're up to no good, to say the least.
Yeah, of course. I think, I don't know if anyone...
But again, it's defining the terms. That's where the key is, defining the terms.
And you'll only do that if you start understanding the fundamental laws and...
knowing who you are.
Yeah.
And the protections you have. And if you're not involved in commerce, then it's been misapplied to you. It's been misinterpreted to you.
And you've helped a few people, haven't you? You've wrote some really fantastic letters that you've complied yourself, pointing out so many facts in law.
Yeah.
And they've left you alone.
They left them alone.
And them alone, that's right. Because I think you had a case even with someone at school wanting to take their child on holiday or something.
Yeah. They're basically friend of a friend, again. The child, for some various reasons, did not want to attend school. Yeah. And as per Education Act of 1996, under Section 8 and Section 444, they were issued a fine.
Right.
So, again, that in itself is not following due process. Because if we look into the Bill of Rights of 1688, it says specifically that all grants, it's not some grants, that all grants and promises of fines and forfeitures without conviction are null and void.
Yep.
So there is a due process. Only after you were called to attend a court hearing, you were given the opportunity to defend yourself. Yeah? Only then, if found guilty, right, then the court has the right to impose a fine. Before that, no.
So really,
because as per A.V. Dicey, the rule of law, that's the breach of the rule of law.
So basically, that we've got a completely rogue system at the moment that's not following any due process.
No.
And if people don't know that they're not following due process, they're just going to argue the wrong thing and get themselves into more.
So what people don't realize is the fact that within the same act, and even the people at school and the people in the council don't realize that within the same piece of legislation, Section 7 says the fact that it places a duty on the parents to make sure that their children attend, are subject to education, if you like. Yeah?
Yep.
Either by regular attendance at school or otherwise.
Right.
Yeah?
Yep. So otherwise, or otherwise.
Again, it's another canon. It's a disjunctive canon.
Right.
right? So, or, for the purpose of this section, or means either at school or otherwise. Yeah, otherwise can be defined as different or in another way. So if you want to take your child at school, if you want a child to attend school, you can, or otherwise you can take him on holiday and teach him something. You know, just even in statutory law, that's the loophole.
In
They
fact,
tell you that the fact that they can't tell you exactly what you can do with your child. It's not child. It's your property.
right. In fact,
Because that is your property.
That's what you say to me. He said a lot of people are scared of legislation, but actually every single piece of legislation has a loophole.
It's there to help you.
It's just
engage with legislation. Learn it. Read the act that they're applying to you. You can find a loophole because they have no authority to tell you what to do.
so when you look at this word or otherwise, it doesn't mention that in the Interpretation Act, does it?
No.
So that means it's not open to anything else.
No. You find and, or, and includes very commonly in pretty much all the acts.
Right.
But these are canons for statutory construction. You need to learn the canons and then learn how to read and interpret what they say. Because he reads different if you don't know the canons.
Right. And you made a point that Edward Coke proved the king is not above the law. So
repeat that again.
When you said to me that it was proven by Edward Coke that the king is not above the law, so we all have the same equal.
That's liberty of the subject of 1628. He is the one of the first to bring to people's knowledge the fact that the king is not above the law, which he isn't.
So how do you feel?
It's there for us.
How do you feel at the
Work
moment?
For us.
Right? How do you?
He called him that he is the highest ranking public servant.
Right. So this brings me on to the next question. How do you feel that now the king is no longer a king but a head of state, and he's no longer swearing his allegiance to the people but to the, say for instance, a lot of people are scared because of the fact that he's involved with the WEF.
Ah, that's a very lengthy conversation. Briefly, we all know about the FCO 34/1048. Yeah, the memorandum of 1971.
Yep.
Yeah, and also we have the Werner report of 1968. We all know that high treason was committed. Yep. But if you go even before that, is it the coronation oath of 1952?
Yeah.
If I'm not wrong. We've seen here is a contract that, it was signed for the people, but it was not signed at the bottom.
Right.
It was signed at the top.
Yeah.
Meaning that nothing was acknowledged past the signature.
Right.
Right. So that in itself is, it begs the question, to say the least.
Yeah. Yeah.
But during his coronation, Charles did mention the Coronation Oath Act of 1688, because William and Mary of 1688, when they sort of come into power, they were acknowledging the fact that they are there in service for the people. They were not above the people. So,
yeah,
it's
it's
how do I put it?
it's proving that, well, it's very hard to try and.
And what does it say? It says that it's there in perpetuity. It's for every future monarch to follow, which Charles did. But at the same time, called himself a head of state.
Yeah.
So that in itself
It's a
is
conflict
what?
of interest
Treason.
there. Yeah, it's treason. Yeah, absolutely. So people are losing faith because they're feeling like you can't have justice with a corrupt government. So but what you're saying is, if we all learn our rights and what they are, then the more of us put pressure on them in the right way, the more justice will be served. Is that what?
It will. More pressure you put, the results will come after. They won't come as quick as people will want them to come, but they will come eventually.
Right. Okay.
The
Right.
easiest way to do it and the most peaceful way of doing this is full non-compliance.
Okay.
Bring everything to a halt should you have to do that. But you have to think that you have this is your duty for future generations.
Yeah.
Because if we don't do something about it now, future generations, our children and our children's children, will inherit an empire of ash, a digital prison.
Absolutely. Right. Okay. Has anyone got any questions? In court, if you win, the discontinue, especially in corrupt cases. Yeah. Farmers are doing it. Non-compliance and stand together, make a wall. That's what a few people are saying. Absolutely. So, if anyone's got any questions, please put them forward now. Yes, the RX1 form. Can you ask him? I don't know. Do you know anything about an RX1 form?
Not familiar.
No. Yeah, Paul, I'll put any links up. Whatever links, just let me know. I think most of the stuff can be found, but I will put some links up in the heading. And is there anything else that you'd like to say? Maybe, when we talk about creature of statute, that belongs to legal fiction.
That is the legal fiction. The creature of statute is the legal fiction.
And so and it's a very common term that they use with us.
Yes. People have been sort of brainwashed into accepting that they are the person. I'm not the person. I'm a man or the individual.
Okay. Well, is there anything else other than council tax that you've had personal success with?
Parking tickets, so-called speeding fines. The same, lay down the law for them and then show them how they've misapplied that whatever statute they're moving under, because they require a vehicle to move under, and the vehicle is the act or the statute. And you show them how they've misapplied that to you.
Right.
And providing you cause no harm, injury, or loss, you've done absolutely nothing wrong.
Yeah. Paul, if you message me, I think we'll talk about to hear more at another time. I will try and see if we can do some more. Someone's asked you register your car.
You have to send the V5C, yes?
Yep.
Now, again, you exercise your commercial code caveat, which allows you to keep your rights. It's been able to enforce your common law rights, your constitutional rights. You're not waving them away. And that's where you put your signature. UD 1-207 without prejudice.
Absolutely. You mentioned something about trusts. Bear with me. I'm just going to try and find it on the notes that I've got here. But where people can protect their rights. It's called.
It's ring fencing.
Ring fencing.
Ring fencing your vehicle.
And that's under trusts, and it's in law. So that's something else that people can look under. How to.
You basically employ the same legal loophole, if you like, that the companies use to enforce liability when they give you a PO box to send the mail to, or your responses to.
So you get your own PO box address and register the vehicle under a trust to that PO box address.
Yes.
And that's called ring fencing.
Yeah, ring fencing. They can't touch it. They can't get anywhere near it. Another practice would be an allodial title over your property, which means God can't touch it.
So apparently,
or a certificate of manufacture,
which you can't find.
Which you can't find.
Yeah. Right. I think I'm going to leave it there for this morning. If there's DVLA refuse a PO box.
They do refuse a PO box if you keep your name. Yes, it does say that on the back of the green slip. However, they do say at the same time that companies are allowed to do it.
So that's why you put it in a trust.
Yes.
So if you put it to the office of trustee, private trust, then it becomes a company. You don't have to register the company, do you?
No. That's your natural person, the unincorporated.
What proof do you need to send? Someone's asked. You don't need to send any proof. You just fill in the...
And the same, everyone who uses the car and drives, lose your license, reapply, but put actually UD 1-207 without prejudice.
And you write without prejudice, yeah?
Absolutely.
Right, so... I'm
still maintaining and keeping my right to travel freely and unencumbered.
Yeah, I think I'm going to do that. So let me just get this right. So people are saying you can't register a vehicle to a PO box, but you can if it's under an office. So on the logbook, you write Office of Trustee. Is that right?
Yeah.
Private trust. And then you put the PO box address.
Mm-hmm.
Because then it turns into a business, an office. And that's interesting, isn't it? They don't want you. What about insurance for car? Well, that has to come to your address, doesn't it? Because that's slightly different, but it's the logbook. Will they accept that? You've done it, haven't you?
Yeah.
Yep. So, and then you can get redirected. You can get your PO box mail redirected to your house. It's not cheap.
Yes.
Maybe £400 a year, but I think, What about VC after the autograph?
VC?
Yeah.
What was that?
I can't remember what that means. I think if you can use that, but I think that could be another method. I can't remember what VC stands for. It's a Latin term that allows you your rights still. But again, it's up to you. If you've gone down that road, you can use that.
You exercise your commercial code caveat.
Yeah.
That allows you to keep your rights. Right.
Under duress. Well, that's VC means under duress, but he's already put UD under duress at the beginning. So UD 1207 under duress, and then your universal code 1207, which means without prejudice, which you reserve your rights. So yeah. So basically, the signature that you put down is not the signature of acceptance; it's a signature of convenience. Right. So Right,
Because
Trevor.
otherwise, you know, the cops will arrest you and throw you in jail.
Yeah. Okay, so Trevor, you're a bit confused. What do you do with the logbook? With the logbook, you write office of trustee, a private trust, and you put the PO box address that you have to pay for through Royal Mail. And if
Not necessarily.
is there another way?
You can grab a virtual address.
A, a, a virtual address?
Yes.
Oh,
Or
interesting.
any other PO box with another company. Not necessarily Royal Mail. Royal Mail will charge about 40
It's £400.
quid a month.
It's £400 a year.
Yeah.
Okay, so there you go. There's other ways.
There's other companies that provide PO boxes.
And then they redirect the post to you. Excellent. Done.
If you want them to.
Yeah. Well,
If not, you instruct the PO box to redirect the mail back to them.
okay, but what if you lose your logbook, or what if you want to sell the car? You need the logbook to transfer ownership.
Basically, get the PO box to instruct you about the mail that you want to receive back.
Yep.
And what you don't want, you don't keep.
Excellent. Okay, brilliant. Right, I'm going to end it there. I hope this has helped. I'm starting, as I said, I'm starting with the first book, which I've got here.
I hope that clears the ambiguity in regards to the person in law and by statute definition, not any other interpretation of the term, or commonly known as.
That it's not a living man or woman.
It's not. It's not a man, it's not a woman. Otherwise, it would say that.
To all men and women.
Yes.
Right, so as I said, at the moment I've got the AV Dicey, which I've been recommended. I know it comes back to front, but it's introduction to the study of the law of the Constitution. This is like an introduction, big introduction. So that's what we're reading at the moment. And then we've got, I can put a list. I think, Ismail, if you can send it to me, I think I've got it somewhere, but I can put a screenshot, upload an image of the list of the books we're going to read. But I think, you know, it is important to understand the foundations of how law was created or how it applies to you. And to understand that you are not the person. And yeah, Jessica, inbox me. It's on Telegram. You can join the group. It's not the person. You are not the person. And the person, so far, from what we've and what Rob has, you know, shown us.
But you have statutory right, and you can enforce it when it suits your cause.
So you can be the person when you want.
Absolutely. There's no rule against that.
Right. And that's it, really. Yeah, so private message me, Jessica. Right, thank you, everyone. I'm going to leave it there. Rob, just wait on the line. I hope you've enjoyed this. Please share it if you have. I'm going to download it and put it in my Telegram anyway. And I shall speak to you very soon. Mwah. Bye for now.